My name is Erica Stolniker, and I'm president of the Duke Law Chapter of the Federalist Society. Our guest today is John Hasnas. Professor Hasnas is an associate professor of business at Georgetown's McDonough School of Business and a visiting associate professor of law at Georgetown University Law Center in Washington, D.C. He teaches torts, white-collar crime, bioethics, and business ethics. Professor Hasnas has held previous appointments as associate professor at George Mason University School of Law, Duke University School of Law, and the Washington College of Law at American University. Professor Hasnas has also been a visiting scholar at the Kennedy Institute of Ethics in Washington, D.C., and the Social Philosophy and Policy Center in Bowling Green, Ohio. His scholarship concerns ethics and white-collar crime, jurisprudence, and legal history. His book, Trapped: When Acting Ethically is Against the Law, is available from the Cato Institute. Professor Hasnas received a BA in philosophy from Lafayette College. He also received a JD and PhD in philosophy from Duke, as well as an LLM in legal education from Temple University. Please join me in welcoming him. Thanks, Professor.
Okay, thanks very much. Thanks for the introduction. It did include the accomplishment I'm most proud of, which is that I graduated from Duke Law School. So I'm an alum. It's always a pleasure to be invited back here. Speakers always say they're glad to be invited to the institution, but it's genuine in my case. It's always a pleasure to visit Duke. I'm going to speak to you about corporate criminal responsibility. The title on the board is actually derived from a local performer here. I don't know how many of you have seen Mike Cross perform. If you haven't, you should, but he's a local performer, he's a musician, and one of his routines is one in which he describes jazz as a musical form in which you legitimize a mistake by repeating it, and then he plays it a couple of times. Well, the thesis of my talk today is that in 1909, the Supreme Court allowed corporations to be subject to criminal conviction in a case called New York Central and Hudson River Railway Company versus United States. And that was a mistake, and we've been repeating it for 100 years. So I'm going to talk about the discordance of New York Central jazz. All right, and in order to do this, I will go back to fundamentals. What I'm talking about is criminal punishment of corporations. So I'm talking about criminal law. And the purpose of criminal law is punishment. When we're talking about criminal law, we're not talking about restitution. We're not talking about compensation. We're not even talking about the regulation of business. Criminal law is punitive law, and its purpose is to punish people who deserve it. That means that a necessary condition for criminal punishment is that the defendant be morally blameworthy. It's a necessary condition. It's not a sufficient condition. I'm going to talk for a moment about moral and criminal responsibility. Moral responsibility implies that one is deserving of punishment. It means that someone has acted in a morally blameworthy way. If you're morally blameworthy, then that's required in order for you to be legitimately subject to criminal punishment. But we don't try to punish everyone who's morally blameworthy. Criminal responsibility is not the same thing as moral responsibility. What's criminal responsibility? Criminal responsibility is the feature that authorizes some human beings to punish others. If we're talking about criminal responsibility, it means someone's acted in a way that justifies other human beings visiting punishment on that person. With regard to moral responsibility, there's a great deal of controversy over whether corporations can be morally responsible for anything. Does it make sense to treat corporations as morally responsible agents? They're groups of people. Is it fair to assign moral responsibility to groups? Does it even make sense? And there's a debate in the philosophical literature. Some people provide arguments that says it does make sense to treat groups as morally responsible. There's another line of thought that says it's completely incoherent to try to ascribe moral responsibility to groups and to corporations. Personally, I think that the skeptics have the better argument. I don't think it makes sense to treat corporations as morally responsible entities. But I'm not going to talk about that today. Let's just assume that it is coherent to say that corporations can be morally responsible for behavior. If that's the case, does that mean that corporations can legitimately be subject to criminal punishment? I'm going to argue no, because corporations shouldn't be subject to criminal responsibility. Criminal responsibility necessarily involves a balancing of competing interests. You punish in order to protect citizens from harm from individual criminals, but you don't want to do so in such a way that you're subjecting people to the threat of harm from an abusive government. You have to balance the interest in protecting against individual wrongdoers and the interest in protecting against erroneous or abusive law enforcement. It means that you've got to draw the line somewhere. You can't try to criminally punish everyone who's morally responsible for bad behavior. So necessarily there's a balancing of interests and there's some line drawing. All right, that would lead to the next question, which is, where do we draw the line? All right, in our system of criminal law, it's not a balanced system. There's a built-in bias in favor of individuals. I call it the inherent liberal bias of the criminal law. If you ask the question, how much risk of punishing the innocent are we willing to run in return for more effective law enforcement, the traditional answer in our system is not very much. All right? And we know that's the answer. Everyone is endowed with the presumption of innocence. That means the prosecution has to overcome the burden on every single element. And the burden is very high. You have to prove every element beyond a reasonable doubt. People have a right to trial by jury. Unanimous verdicts are required. There's a long list of things I could talk about, but perhaps the most famous way of expressing this comes from William Blackstone. In his commentaries, he has the statement that's often quoted, which is better that 10 guilty men escape than that one innocent should suffer. And that represents the built-in inherent liberal bias in our system. We do want to punish the guilty, but not at the risk of visiting an incorrect punishment on the innocent. So the line is drawn fairly far over toward the liberal side. All right, that's the theory. How is it operationalized? For those of you that know me from last semester and were in my class, the next slide's going to be very familiar. You've seen it before. But there are basically three necessary conditions for the application of criminal punishment. There are these three conditions that I would say operationalize the inherent liberal bias in the criminal law. The first says that criminal sanctions may be applied only when doing so advances a legitimate purpose of punishment. Second is that criminal sanctions may be applied only when doing so does not create an unacceptable risk of prosecutorial error or abuse. And then the third is criminal sanctions may be applied only where necessary to address a public harm. By adhering to these three, we punish the guilty in a way that does not expose the innocent to too great a risk of incorrect punishment. All right, that's the setup, that's the fundamentals. Now I'll turn my attention to corporate criminal responsibility. What does it mean to punish a corporation? What's the standard for criminal liability for corporations? Well, that standard is the New York Central Standard. It's a standard that the Supreme Court created in the 1909 case. And that standard is respondeat superior liability. Corporations are strictly liable for the offenses of their employees that are committed within the scope of their employment. It's the same standard you learned in tort law for when an employer can be held liable for the torts of an employee. That's the same standard that tells when a corporation can be convicted of an offense. It's whenever an employee has committed an offense within the scope of his or her employment. It is strict vicarious liability. So that's the standard that we're talking about. What I'm going to suggest to you today is that this standard of criminal liability violates all three of those conditions and therefore is unjustified. Okay, the first condition says that criminal sanctions may be applied only when doing so advances a legitimate purpose of punishment. Okay, what are the purposes of punishment? This can be sliced up differently, but the three main ones would be retribution, deterrence, and rehabilitation. Why doesn't corporate criminal liability serve any of these purposes? Well, to begin to answer that, you have to consider what punishing corporations consists of. What does it mean to punish a corporation? Corporations have no bodies. They have no minds. They can't be incarcerated. Imprisonment's not available. The only punishment that can be inflicted on a corporation is a financial punishment. And you can fine them, you can revoke their licenses if you want to, but that's still a financial punishment because all it does is undermine the corporation's ability to make money. You could even liquidate it under certain circumstances, but it's still a financial punishment. If a corporation is given a financial penalty, who pays? The people who pay directly are the owners of the corporation, which means the shareholders. On the other hand, you can say there are some incidental costs. If the fine increases operating costs, the cost may be passed on to the consumers. If there's a cutback in employment, it's passed on to the employees, but those are incidentals. A financial punishment on a corporation is paid by the owners. However, the owners are not the people who committed the offense. The people who committed the offense are the employees. The defining characteristic of the modern corporation, you've probably heard this, is that there's a separation of ownership and control. The owners don't control the behavior of the corporation, they don't control the behavior of the employees. So the punishment necessarily falls on people who have not committed the offense. In other words, the punishment necessarily falls on the innocent. And punishing the innocent doesn't serve any of the purposes of punishment. I'd consider retribution first. What does it mean to punish for purposes of retribution? That means you're visiting an evil on someone who's done wrong to requite the evil done. It's imposing a harm for harm done. Retribution only justifies punishing the person who's committed the offense, himself or herself. Vicarious liability can never be justified on retributivist grounds. That's almost definitional. So corporate criminal liability can't be justified on retributivist grounds. What about deterrence? In our system, punishing for deterrence means punishing people who have committed an offense or done something wrong as a warning in order to discourage other people not to behave in the same way. Deterrence does not refer to punishing the innocent to get them to try to suppress the activities of their fellows. There's no doubt that punishing corporations can deter wrongdoing by corporate employees if what happens is you get the corporate structure to impose enough monitoring and other types of behavior. But this is not different in principle from the following. There's also little doubt, I believe, that we could suppress the amount of crime done by teenagers if we could punish their parents for their offenses. That would have a deterrent effect. It's just not a legitimate one. In principle, this is no different than the Nazi practice of punishing the members of a community where sabotage occurred in order to get them to suppress the action of future saboteurs. It does deter, it's effective in a sense, it's just not the kind of deterrence that's justified in a liberal legal system. Our form of deterrence requires punishing wrongdoers as a signal to others. So you can't justify corporate criminal liability on deterrent grounds. And the story's going to be the same for rehabilitation. Rehabilitation refers to actions designed to change the character of a wrongdoer to make that person behave in a socially acceptable and responsible manner in the future. Rehabilitation means correcting or changing the behavior of somebody who's engaged in wrongful action. You can't rehabilitate the innocent. You can only rehabilitate a wrongdoer. Rehabilitating the innocent is just depriving individuals of their liberty. I've often heard prosecutors justify corporate criminal liability on grounds of rehabilitation by saying, we can make business people behave better through this mechanism. But getting people who haven't engaged in wrongdoing or threatening them with punishment in order to make them behave better is not rehabilitation. That's just coercing people to behave the way the government would like them to behave, which is an infringement on their liberty. This is not different in principle from some practices from the Soviet Union, where those who disagreed with government policy were sent to psychiatric hospitals so that they could be made to behave better. Again, this is not the kind of justification for punishment that works within a liberal legal system. So I'll submit to you that corporate criminal liability doesn't serve any legitimate purpose of punishment. All right, let me go to the second condition. Sorry about my voice. Oh, and on this, corporate criminal responsibility can't be justified under any purpose of punishment because the collective punishment of the innocent along with the guilty can't be justified. The best illustration of this is, give me an example of a corporation that you think should be subjected to criminal punishment. What's the poster child for the corrupt corporation these days? What are you going to say? No, not Goldman Sachs. Enron. People will come up with Enron first. Enron is the poster child of the corrupt corporation. Was Enron prosecuted? No. Why wasn't Enron prosecuted? Why won't Enron be prosecuted? Well, think about it. Who were the main victims of the fraudulent behavior of the employees of Enron? The shareholders. If you prosecute Enron and you punish the shareholders by taking more money away from them, what good does it do? Enron's not prosecuted because the government is aware of the fact that prosecuting Enron is just punishing the victims in addition to the crime itself. So that's the argument on punishment. What about the next condition? Second condition is you don't want to punish where it will generate too high a risk of enforcement error or abuse. And that's operationalized through three conditions. What that means is criminal provisions must place objective limitations on prosecutorial discretion, provide adequate opportunity for parties to conform their behavior to the law, and minimize the likelihood that the innocent will be punished along with the guilty. Corporate criminal responsibility violates all three of those conditions as well. Why does it play? Corporate criminal responsibility places no limitations on prosecutorial discretion. Why? If an individual employee commits a crime, the prosecution is limited by the need to establish each of the elements of the offense. It's got to prove the actions and the mens rea. It can bring charges when it has evidence on each element. What's required for the prosecution to bring a charge against the corporation? Nothing more. There are no additional elements of proof required to charge the corporation in addition to the individual. Whether the corporation is charged is 100% entirely up to the discretion of the prosecutor. There's no elements of proof required. This is a standard that invites abuse. The governor-elect of New Jersey, Chris Christie, is famous because when he was a U.S. attorney, he negotiated a deferred prosecution agreement with Bristol-Myers, and part of the deal was Bristol-Myers would endow a chair in business ethics at his law school, at the law school that he went to. So there's the business ethics chair. Why did Bristol-Myers do this? Because Bristol-Myers has to do whatever it wants to satisfy the potentially prosecuting attorney in order not to be indicted. There's no limit on discretion with corporate criminal responsibility. Okay, what it means is that the Department of Justice policy today is whether or not a corporation is indicted depends on whether the corporation cooperates with the prosecution, which means the corporation has to serve the interest of the prosecutor in order to avoid indictment. That's open season. There's no limit on discretion. You simply have to do what the prosecution wants. On the other hand, the second condition is that corporate criminal liability has to, it provides no opportunity for corporations to comply with the law. Why? Individuals can exercise self-control. If I know what the law is, I can refrain from violating it. All I have to do is control myself. What about a corporation? A corporation is guilty of an offense whenever any individual employee violates the offense. Every corporate manager knows that no matter how good the internal controls that they enact, you can't control the behavior of all of your employees. It's not possible to guarantee that no employee will violate the law. The leading case on this is the Hilton Hotels case, in which Hilton Hotels had a corporate policy against a certain action and had given explicit instructions to its employee not to engage in this action. And in testimony, the employee asked why he did it anyway, explained he was just angry and in a fit of personal pique because he didn't like this guy, he did it. Corporations can't control the behavior of their employees, therefore they can't guarantee that they won't violate the law. There's no opportunity for them to ensure that they'll conform their behavior to the law. And the third condition is that corporate criminal responsibility ensures that the innocent will be punished along with the guilty. All right, corporate criminal liability is intended to punish the innocent. The government can go after the individuals who've committed the offense, no problem. They're guilty, they can be prosecuted. If you go after the corporation as well, you're going after people who have not committed the offense, and you're trying to impose a fine on the shareholders. It's intended to punish the innocent. In a sense, corporate criminal responsibility is inherently abusive. Its normal use violates this proposition. So, my contention is corporate criminal liability creates an unacceptable risk of enforcement error or abuse. All right, third condition was public harm. The criminal sanction may be applied only to address harm to a societal rather than a private interest, and it can be used only when it's necessary to protect such an interest. Well, think about corporate criminal responsibility. Fraud, embezzlement, any of the white-collar offenses, they do pose a real risk to a societal rather than a public harm. To the extent that they destroy people's willingness to engage in market transactions, to the extent that they make undermine faith in markets, that's a public harm. But that's a harm committed by the individual, whether that person is functioning in the private sphere or by himself or in a corporation. It doesn't matter where the action takes place. What's the public harm committed by the corporation as opposed to the individual? There isn't any. The harm that's associated with corporate criminal responsibility is exactly the same harm that's associated with the action of the individual. Corporate criminal responsibility doesn't punish a distinct societal harm, it just punishes the same harm twice. There's no interest being protected by the punishment of the corporation that's not already fully vindicated by punishing the individual. Sometimes that argument's a little too metaphysical, so even if you don't buy it, even if you think that somehow you are vindicating a public interest by punishing the corporation, it's not necessary to punish the corporation in order to vindicate that interest. Why? You can punish the individual. A threat to punish an individual and send them to jail is more likely to protect the public interest than a threat to fine his corporation if he does the same thing. So individual criminal liability is already an option. Number two, if you want to, you can regulate corporate behavior. That's what the administrative law is all about. So if you want to regulate corporate behavior, you can do that. You don't have to have criminal punishment to vindicate that interest. And finally, if a corporation engages in some kind of fraudulent behavior that causes harm to people, and especially the shareholders, there's civil liability. Shareholder derivative suits can be brought up against corporations, and that results in large judgments, sometimes punitive damage judgments. In the 1990s, Congress thought that civil liability through shareholder derivative suits was too great, and they passed two statutes to dial back shareholders' ability to sue corporations. If the Congress thinks that civil liability is too punitive, how can it possibly be the case that an additional level of liability, which is corporate criminal liability, is necessary to protect the interest? It can't be. So corporate criminal liability is not necessary to prevent any public harm. Okay, if I'm right, if corporate criminal liability violates all of the three necessary conditions for criminal punishment, then why do we have it? What's the rationale that the Supreme Court used to allow corporations to be punished? There's its rationale. Applying the principle governing civil liability, we go only a step farther in holding that the act of the agent, while exercising the authority delegated to him, may be controlled in the interest of public policy by imputing his act to his employer and imposing penalties upon the corporation for which he is acting in the premises. Apparently, it's a matter of public policy. Well, what is the public policy interest that's served by punishing the corporation? According to the Supreme Court, if it were not so, many offenses might go unpunished and acts be committed in violation of the law. Apparently, the public policy interest that's served is the interest in more effective law enforcement. The only problem with that is a public policy interest in more effective law enforcement, can never justify overriding those aspects of the criminal justice system that are designed to protect citizens' civil liberties against law enforcement agents. If we have built into the system certain features that are designed to protect us against overreaching by law enforcement, the need to have more effective law enforcement can't possibly be a justification for overriding them. Recognizing such an interest would be a repudiation of the fundamental theoretical structure and the normative values inherent in the criminal law. It's inconsistent with the liberal bias of the criminal law. The purpose of the liberal bias in the criminal law is to make it difficult for the government to deprive citizens of their liberty in questionable cases. That's why the law is structured this way. Crimes that consist almost entirely of what's in the defendant's mind are such cases, and most of the modern federal white-collar criminal offenses are exactly of this type. Federal fraud isn't fraud, it's attempted fraud. It's participation in any scheme or artifice to defraud. There are no visible aspects of the actus reus. The offense is almost entirely a mental offense. What were you planning to do? Many of the offenses are conspiracy, which is, again, mostly a mental offense. Many of the offenses, like money laundering, consist of perfectly innocent use of your funds with the knowledge that they were generated by past criminal activities. On its surface, looking at what's happening, there's nothing in the conduct of the individuals that suggests criminal behavior. To prove the case, what the prosecution has to do is prove something about the mental state of the actor. That usually can come down to one person's word against another. That's the area of law in which the risk of prosecutorial error or abuse is the greatest. That's the type of law for which we want the inherent liberal bias of the criminal law to be most effective. White-collar offenses are precisely the type of offenses that we would like it to be difficult to prosecute. You can't say that the interest in more efficient law enforcement justifies overriding these provisions. Now, let me make a confession. I'm here. I'm happy to be here. I was thrilled to be invited by the Federal Society. I'm speaking for the Federal Society. But despite that, I confess, I don't care about corporations. I don't care about corporations. I'm not even that concerned about shareholders. We are punishing the innocent. That's a bad thing to do. But what do they lose, right? They lose their investment. Who cares? Right? They probably are diversified anyway. Right? I don't care about this. The reason why I'm making the argument, and I believe the argument's a good argument, the reason why I'm making the argument is because I care about the individual citizens in society. The purpose of corporate criminal liability is not to punish corporations. Today, there's an ever-increasing number of investigations of corporations and an ever-decreasing number of indictments. Why? Because the Department of Justice doesn't want to indict and doesn't want to convict corporations. It wants to force corporations to cooperate with the federal investigators. It wants to, and there's a good reason for that. It's impossible for the Department of Justice to enforce the law of white-collar crime on all of the business and business peoples in the United States at its own expense, with its own resources. No matter how large the budget of the Department of Justice is, it doesn't have enough. The only way to do this is to get corporations to do the job for it, to get corporations to become deputy prosecutorial agents, to perform the functions, to do internal investigations, and to turn the information over. The Department of Justice wants cooperation. It doesn't want to punish corporations. In fact, it doesn't want another Arthur Andersen. So many innocent people lost their jobs as a result of the actions of one or two that the Department of Justice didn't look so good for a while. That's what it would like to avoid. Today, the offense is not the crime. The offense is failure to cooperate, and the punishment is corporate indictment, which alone can be a death sentence. It's not that you have indictment and then the purpose is punishment. The purpose is cooperation, and the punishment for failing to cooperate is indictment. Corporate criminal liability doesn't serve any of the purposes of punishment because its purpose is not to punish. Its purpose is to conscript corporations into the law enforcement effort. What's so bad about that? What's bad about that is it's inconsistent with a liberal legal system. The purpose of the liberal bias in our system is to restrain the scope of social control that the state may exercise through the threat of punishment. How can it do this? It does it in many ways. We've got a long list of protections. But one of the main ways in which it does it is it forces the state to establish its case itself. The presumption of innocence, the reasonable doubt standard, the right against self-incrimination, attorney and client privilege, put all these features together, and what you've got is a mechanism that says, in order to convict, the state has to generate, supply the evidence by its own efforts without being able to force the individual to aid in his or her own prosecution. The mechanism by which we restrain the state is the requirement that it establish its case by its own resources. If the state's required to make its case with its own resources, that limits the number and the breadth of criminal statutes it can enact. It can't enact amorphous, broad, overreaching statutes of uncountable number if it's got to prove the case in every single, it has to prove guilt in every single case by its own resources. If you allow the government to export the cost of law enforcement onto the private sector, as we do with corporate criminal liability, then we remove the limitation. Now, by being able to outsource the law enforcement function, there's no longer any limit to the breadth of the number of statutes that Congress can pass to limit the liberties of the individual citizens. Corporate criminal liability is incompatible with the maintenance of a liberal system of justice because it frees the prosecution from the need to meet its burden itself. That's the danger of corporate criminal responsibility. I'm not concerned about corporations. I'm not concerned about shareholders. I'm concerned about all of us. I'll close with an example. KPMG was being investigated for potentially abusive tax shelters that it had marketed. Up until a certain point in time, KPMG argued that its tax shelters were legal and that they weren't abusive. As soon as it came under investigation from the Department of Justice and the risk of indictment came on the scene, with the idea of what happened to Arthur Andersen in mind, KPMG changed its position entirely. It immediately said, these are illegal tax shelters, we're guilty, we'll pay you $4.56 million. We will do everything in our power to help you prosecute our own partners and employees, including refusing to pay their attorney's fees, waiving our attorney-client privilege, turning over all documentation to you that will help make your case, not supplying any documentation to the defendants. Now, it's possible that every single defendant was guilty and had knowingly engaged in the sale of fraudulent tax shelters, in which case there might not be much objection. But many of these partners weren't attorneys. Many of these partners who were marketing it thought that what they were marketing was legal because the people who worked at KPMG and the legal department kept telling them that these were legal tax shelters. These people, in my mind, have a pretty good defense to a charge that they engaged in fraud. Fraud requires intentional action. You've got to know that you're selling a fraudulent tax shelter. What was happening was KPMG was making it so that these people were unable to successfully defend themselves. Why? If you're charged with a crime, what's your defense? I mean, in a case like this, the defense is the business records that are in the hands of the company, or the testimony of co-workers. Once KPMG had made its agreement with the government, it refused to turn over any business records to the defendants that they asked for. But worse than that, in order to make one of these agreements with the government, the last clause in every deferred prosecution agreement is one that says, no agent of the company will make any statements inconsistent with the agreement. What that means is, if anybody who works for the company says something that's inconsistent with the guilt of the company, and the only way a company can be guilty is if the employees are guilty. So if anyone says anything inconsistent with the guilt of the individual employees, that person's got to be fired. Otherwise, the company can lose its deferred prosecution agreement. Where are you going to get your witnesses if you're an individual trying to defend yourself if everyone who works for the company knows that if they speak on your behalf, they'll lose their job? It's called, the prosecutors have a term for this, it's called icing the witnesses. But the reason why we should be concerned about corporate criminal responsibility has nothing to do with corporations. It has to do with the power it gives the prosecution to get around the civil libertarian protections of individuals and the risk that individuals suffer as a result of this. So I'll stop there and entertain any questions that you have. Sure.
In that position. So the individuals that are now sort of put to blame because of the DPA, don't they have to get the information because of like discovery rules? They would have to get some of those documents?
Yes and no. All right. Let's talk about documents and testimony. All right, testimony, you can subpoena people. All right, so if people won't voluntarily testify for you, you can issue a subpoena and require them to testify. How cooperative they'll be is questionable if they know making a statement inconsistent with the guilt of the person that they've been subpoenaed to testify for will cost them their job. So it's harder to get witnesses. You can get them through the subpoena process. Can you use the discovery process to get information? Well, the government has to turn over any evidence that it has that's exculpatory. All right, and you can use the discovery process, but it adds to the expense. Right? If the company will give you the records that you want voluntarily, it's much less expensive than having to go through this process where you're paying lawyers' fees all the time. Defending yourself in one of these trials, minimum, is $300,000. The Department of Justice policy has been changed since 2006. The Department of Justice will no longer consider the refusal to advance attorney's fees to employees as a lack of cooperation. Actually, doing that in the KPMG case got the KPMG case overturned on constitutional grounds. A court in New York in a case called United States versus Stein said this was a violation of the Sixth Amendment right. They were making it impossible for the people to get the attorneys of their choice. So that's gone. But even with that, if you can add to the expense of the defense enough, it makes it more likely that you'll get a guilty plea. And that's what they're after. So yes, I mean, you can use the discovery process, but the mechanism makes it more burdensome to the defendants. And what this is really about, in a lot of ways, is jacking up the cost of defending yourself. Yes, sir.
So, if I was a stockholder in a company that was then indicted criminally, don't you think that my profiting by that company's wrongdoing through my stock going up or what have you, like take the Enron case? I mean, don't you think that makes someone culpable enough that it's really not a grievous deprivation of liberty to penalize them for their having profited?
No. Do I have a lot of sympathy for the stockholders? No, I don't have a lot of sympathy. I have a little sympathy. Right? The stockholders make an investment. If someone else commits a crime, they're already on the hook, right? If someone in a business commits a tort that causes a loss to someone else, the company can be sued and you have to pay compensatory damages. Sometimes you have to pay punitive damages. It's going to hurt my investment. Is there any justification for imposing another financial penalty beyond that on the stockholder to represent a punishment for blameworthy behavior? No, because there's no blameworthy behavior. And if we do say that the blameworthy behavior is investing in a corporation in which employees engage in wrongdoing, then what we've just done is turn all of the little old ladies sitting on their couch at home into criminals, because all they did, after all, was put money into their mutual fund, which then was invested in corporations. It's not a great harm. It's not a great evil that's being done to the stockholders. It's just unjustified, and what's worse is it's an unjustified mechanism that gives the government enough power over the corporation to circumvent the rights of individual defendants. So I'm disagreeing with you, but not strongly. You're not acting in a blameworthy way for investing in a corporation, an employee of which commits a crime, since not only can't you, if you invest, you don't control things anyway, but even the corporate management, even companies with the strongest possible programs to produce an ethical culture can't guarantee it won't happen. It's just not blameworthy behavior, and that's what's required for criminal as opposed to civil liability. Yeah.
So some of the innocent people that get hurt by this are just, standard employees that might lose their, like at Arthur Anderson, that lose their job. But this isn't like a main reason, but people don't have a right to work for a particular company, and especially companies whose employees engage in bad business practices. I mean, I sort of feel like those people are should be lumped in with like the stockholders. Like I feel bad for them, but you don't have a right to your job. And do you? I don't know if that was part of the basis. That's not part of the basis of your argument, but
I understand the question. This may be a matter of how sympathetic we are. Right? Do I have a lot of sympathy for stockholders? No. Do I have a lot of sympathy for employees who lose their job? Well, no, you're right. You don't have a right to a job. Do I have some sympathy? Yes. If I'm doing my job in a company, I'm doing it in a proper way, I haven't done anything wrong, and somebody else commits a wrong, the result of which is I receive punishment or I receive some negative, I end up losing my job, yeah, I'm a little upset. Is it the worst thing in the world? No. It's just unjustified. This form of criminal punishment, collective punishment and vicarious criminal punishment, is unjustified. Punishment can only be imposed on people who've acted in a morally blameworthy way. We have other mechanisms in our system for dealing with this situation. That's why respondeat superior liability exists in tort. The master can answer for the torts of the employees. Something else, blaming the master who's not guilty for the offenses of the employees, that's not legitimate. And it does have these downstream consequences of causing losses to others. The interesting thing is, this is my argument, a companion article in the same book that this is coming out in, wonderful article by a University of Michigan professor who's a lot funnier than me. He gives examples of what corporate criminal responsibility does, and he talks about a case in which 5 pharmaceutical companies were prosecuted, well, they were threatened with prosecution for giving illegal kickbacks, or taking illegal kickbacks that increased the cost of their prosthetic devices and their drugs to the consumer. In fact, that was the case brought by Christie, and Zimmer was the company that he was prosecuting. That's the company that endowed the business ethics chair at Seton Hall. That's why the case is known. So after it was all over, what were they threatened with? The crime was increasing the cost of these things to the consumers. The punishment was to impose a fine on the company, which it can only pay either by taking from the stockholders or by passing on the cost to the consumers. So the punishment for jacking up price to consumers is to jack up the price to consumers even more. All right, that thing's a big circle that makes no sense. The purpose is not punishment. The purpose is to force cooperation and outsource the cost of law enforcement. Yes, sir.
I'm just kind of, with your talk about overzealous prosecutors, do you think absent a corporate liability theory that prosecutors would then be encouraged to kind of develop these elaborate conspiracy theories that might impute relatively large liabilities on people that were relatively minor actors in their wrongdoing?
Yeah, this is a very good question. There are some overzealous prosecutors. Excuse me. There are some overzealous prosecutors. I don't think that's the problem, though. Right. The U.S. attorneys, by and large, are sincere, dedicated people who are doing their job to the best of their ability. They represent the United States of America, and as all attorneys, they've sworn an oath to protect their client's interest and to pursue their client's interest zealously. Given the situation they're in, they're acting in a perfectly logical and rational and ethical way. They've got limited resources. The laws that they have to enforce are extremely broad and entirely amorphous. The federal fraud offenses have been described by the Second Circuit Court of Appeals as virtually limitless in reach. Almost anything that constitutes dishonest business conduct is a federal offense. Scalia, not that facetiously, said, if I call in sick and go to a baseball game, I'm actually defrauding my employer of his right to honest services. This is a case that's going to be heard by the Supreme Court this year. So the offenses are very, very broad. They cover the entire business community of the country. There's limited resources. What can you do? Most prosecutors are doing the best they can with limited resources. They can't do the job without imposing the cost on businesses. So that's the motivation. If we got rid of corporate criminal liability, what's the result of that going to be? Many of the laws that are currently on the book become virtually unenforceable. Why? Because they're precisely the type of laws that Congress shouldn't be making in the first place. The internal structure of the criminal law, I'll give you an analog, it works a little bit like the way the federal Constitution is supposed to work. The federal Constitution was designed to create a national government with strong powers but limit its use. A strong but limited national government. The restrictions curtail how much the federal government can do with the strong power that it has. Well, criminal law is the same thing. Criminal law authorizes the state to act against individuals in order to suppress harmful behavior. But we don't want the state to have too much power to suppress individual activity. That interferes with liberty. So it's a blunted sword. It limits the kind of things that you can go after through the criminal mechanism. Congress has broken through those limits. The situation we're in is we can now get rid of the civil libertarian aspects of the criminal law in order to make these overly broad statutes more enforceable, which is what the Supreme Court did in the New York Central case, or we can maintain the limits in the criminal system and discourage Congress from passing these kind of laws. I'm arguing that we've gone in the wrong direction. The reason for my opposition to corporate criminal responsibility is civil libertarian. It will restrain the amount of social control Congress can exercise by threatening people with criminal punishment. Now, did that respond to your question or not?
Well, I mean, I guess I just see there's this public opinion coming up against these actions that corporations take that are harming these people, and absent corporate liability in some cases, I think the government would be, or a prosecutor could be compelled kind of by public opinion to have to blame somebody because we want to blame somebody.
Yeah, but that's okay. No, that's okay because in order to prosecute a corporation, you have to have an individual who's committed a crime first, right?
Right. And
without this, you have to go after the employees.
And my question is then, how do you think it's like, I could see a situation where they're developing this elaborate conspiracy because it took several employees to do it, and blame for the whole conspiracy is being imputed on somebody who played a very minor role. And so... Okay, yeah, it's a very good point. One of your professors here, Sarah Sun-Beal, she makes this point all the time. I entirely agree with her. I'm arguing against corporate criminal liability, but if you get rid of it, you still have all of the rules of criminal law that exist now, which she thinks empower the government to engage in overreaching against individuals. If this goes away, will the prosecution go after individuals on a conspiracy theory that can sweep up people who are only marginally related? And actually, this happens all the time. You get somebody who doesn't even know he's in a conspiracy. He's engaging in mutual knowing cooperation with others. He doesn't like what they're doing, but he's not trying to stop it. You go after him first. You arrest him. You make him turn state's evidence. That's how you get all the others. There are a lot of problems with the way the federal government enforces laws against individuals. We can talk about that forever. I'm a civil libertarian on that scale as well. So that's a real risk. But this
makes it so easy you don't even have to go through the trouble of having these kind of conspiracy theories. You just get the government, the company, to do all of the work for you and hand over the defendants on the silver platter. Your concern's a real one. I share it. But to get to that concern, we have to get past this one first. And now it's so easy to convict that we don't even have to have the prosecution making these wide-ranging conspiracy theories. Yes?
Is there some sort of in-between between both of your arguments? Like, what if you held a corporation, you can't, respondent superior doesn't apply, conspiracy doesn't apply if you have an accomplice liability theory, something like that, where the individual can't succeed without the corporation arguably in some situations, not all, creates an environment where criminal conduct is ignored or encouraged.
Yeah, no, it's great. Yeah, is there some midpoint between the two extremes? Absolutely. You're not going to hear it from me. Right? I think there should be no corporate criminal responsibility. I think it's a matter of principle. That's it. But that's because that's the way I am. My solutions are not practicable. And nobody's going to listen to me, and that's not the way things are going to come out. So the people who actually want to change the world and have some effect are talking about the mid-range. And there's a lot of proposals that are improvements. One is you can add an element of proof for corporate conviction. See, I think convicting groups is nonsense. But if you want to have corporate criminal responsibility, can you have a better standard? Yeah, Andrew Wiseman, who was the director of the Enron task force, so he used to be a prosecutor. Now he's working for Jenner and Block. He's just written that in order to convict a corporation, you should have to prove, the prosecution should have to prove that the corporation has not taken reasonable steps to have a good corporate culture, or the corporation has engaged in things that, has failed to engage in things that would reduce employee criminality. Now there's an additional element of proof required before you can convict a corporation beyond what the individual has done. So that limits prosecutorial discretion. It also makes it possible for corporations to obey the law. If they have a good compliance program, they know that they're okay. Other people have said you can allow that to be an affirmative defense. An employee commits a wrong, you can come in and prove affirmatively that you've got a compliance program. The Model Penal Code has a different standard. There are a lot of intermediate points. They're all improvements. The reason why they're improvements is the purpose of this standard is to shift the balance of power way over to the side of the prosecution relative to the defendant. These mid-range positions pull it back. It makes it a little bit more balanced. So they're good solutions, and there's some chance that they can be enacted. Wiseman wrote a brief in a recent case, the Iona management case, arguing that the court should go to something like this and that New York Central didn't actually control all cases. The Second Circuit took about 2 seconds to say, no way. This was dismissed out of hand. But these arguments are intermediate points. There are less radical standards that still allow the punishment of corporations and don't have all of these problems. I'm not going to support them because they're still unjustified, and they still, almost all of them work the same way. Your defense is to have a corporate compliance program, an effective corporate compliance program, and that's defined in the organizational sentencing guidelines, and it's defined by lawyers, and everybody thinks it's great. But when you go out and you do this other kind of research that we don't do because we're in law school, empirical research, and you study the way things work, you find out that corporate compliance programs are virtually ineffective. Sometimes they have reverse effects. And why? Because they've got nothing to do with the way businesses operate. They're punitive. They require intense monitoring. You have to be looking at what the employees are doing all the time. You have to have severe sanctions. You have no tolerance policies. Well, you know what? That doesn't actually reduce employee criminality, because there's another type of research done in across the street over at Fuqua, the organizational behavior people, who study how corporate structures influence individuals. And it turns out that if you treat your employees with respect, and you invest them with a lot of trust, and you reward trustworthy behavior, and you do punish severely, but only after you have this procedural justice approach. They call it organizational justice. That reduces employee wrongdoing massively more than a punitive compliance system. And apparently the reason is the employees start to think that their values and the corporate values are in a line. And when they see other people engaging in wrongdoing, they take it as an offense against themselves and not as against some impersonal corporation, and they come forward with more evidence, and you get a better, a more ethically functioning corporation. At the moment, our legal structure virtually outlaws the more effective approach. If you trust your employees, if you have this organizational justice approach, and some employee commits a crime, when you're a prosecutor, when the prosecutors come to call, do you have an effective compliance program that meets all the organizational sentencing guidelines to say, look, here, we've got this? No. We're not even checking these guys out. We're trusting them. It's a prescription for indictment. So one reason why I'm not in favor of it is it's not going to be an effective method anyway. That's in addition to the fact that it's not justified on principle. But you're on good ground. Most of the proposals are exactly what you're thinking about. Yeah. Other questions? No other questions? I'm sure I wasn't that convincing. So most people love the idea of punishing corporations, right? It's a non-starter to say that there should be no punishment of corporations. But it just doesn't make sense. Corporations don't have brains, they don't have bodies, they don't exist. They're fictions, there's only human beings, and only human beings can act in a morally blameworthy way. And that means only human beings can be subject to criminal punishment. Punishing corporations is just a way of getting some human beings to do the government's work for it, and that's the last thing we should want. Okay, so I think I'm done.